So we are into chapter 7, which more importantly is the Assistance of Counsel, right, in our book. So if you have your book, you may want to follow along a little bit. So what I have to start with is just, your full text of the Sixth Amendment, because again, I think it's exciting from a historical perspective to realize, the amendments to the Constitution, I mean, it took a few years, but 1789, right, is really when you get the signing of everything. So 1789, out of that time period, you get the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, all dealing with your rights in a criminal setting. So the founders of the country, almost 300 years ago, really looking at how your rights would face off against the government. Oh, the screen, is it not working? Maybe let me know if you guys can see the screen. Okay, I don't know. So it's exciting to think that something that was written in 1789 has such a huge impact on how we interact with our criminal justice system right now. This isn't a history class, but there is a lot of exciting, that it's really current right now, and to think how important that is. So what I have here is just the text of the Sixth Amendment, and you can read through that at your leisure. But what comes out of this are a few things, right? The right to trial, what we would call the speedy trial rights, okay? Your right to a jury, and then your right to confront witnesses, which is often known as the Confrontations Clause. So kind of cool when you think about it in those terms. The Confrontation Clause, right? So the defendant has the right to confront the witnesses against them. And then from there, you get into some kind of twisty-turny issues. And there's like a little bit of kind of double information in this lecture. But at any rate, so sometimes the question then comes into, does the defendant have to be there during the trial? And there's been a lot of historical development over time, so for a time it was like, well, no, the defendant doesn't have to be in trial. I mean, we're talking the 1800s, and then eventually we get to where we are now, which is basically the defendant does have to be there, with a few exceptions. So this is kind of picking up on pages 160 in your book, if you want to follow along with that. And going forward, there's a whole lot here. Just wondering how much it's worth going into that in depth yet. So one of the things that can come up of when you would have a case where a defendant wouldn't be there is if you have the disruptive defendant. So all efforts should be made to keep the defendant in the trial, like in the room. But if they are completely being disrupting, you could imagine like you have a witness who's on the stand and testifying against the accused, against the defendant. And maybe while they're doing it, the defendant is up there yelling at them, screaming at them, making like, I'm gonna cut your throat kind of actions. They're actively intimidating the witness or being disruptive to the court so that people can't hear, people can't listen to the information. So in that sense, you can have the defendant removed for being a disruption. This would be very extreme. They would want to set a very clear record that they had to have the defendant leave for that purpose. There's a couple important cases here. I don't know, we might come back to Illinois versus, any rate. But so the Supreme Court has said, right, if you look on page 161, they upheld the conviction because they noted that lost by consent. So if the defendant says they don't want to be there or agrees not to be there, or by disruptive misconduct, okay? So again, if the misconduct is so great, that can be a problem. One of the things you would want to look for though, is the disruption being done, kind of, from a, what would be the word, like a malfeasance, where they're trying to create a trouble, or are they being disruptive because they maybe are having a mental break or some sort of issue, they're having what would be the word, incompetent. So are they being disruptive because they can't actually bring their conduct into focus? They can't bring it together. And in that case, the proceeding should stop because at all times the defendant must be competent. So you would want to investigate, is the disruption being caused because the defendant's trying to be disruptive, trying to hurt the process, trying to intimidate people, or is the disruption being caused because the defendant has in some way become incompetent? And in which case, that's a very hard standard, that the defendant must be competent at all times during the trial. So this is separate from the issues of not guilty by reason of insanity, totally separate issue. This is competency during the proceedings, and the defendant must maintain competency. So that's where some of the examination would want to take place. Is there a chance that the defendant's being disruptive, shouting things, or who knows what, because they actually have lost some competency? So most of the time, the whole proceeding would be halted, and there would be some investigation into the defendant's mindset, mental capabilities, to determine. And then if it really is like they're doing it on purpose to be disruptive, they could continue without, at least from a constitutional basis. So questions or comments on that one? I'm just looking at the book. I'm like looking down. Then we get to the right to counsel, the right to an attorney, right? The right to have an attorney. Oh, is there a question? Or right to have an attorney. If you have a question, feel free to jump in or post up a chat. And just in my class yesterday, it kind of came up. So right now, the right to an attorney, the right to counsel, from a federal constitutional standpoint, is only for criminal cases where you're facing really incarceration. You do not have a federal national right to an attorney when you're facing family law or eviction, or even an immigration case. There is a lot of social justice movement and focus on those issues that perhaps you should have a right to counsel in an eviction or in a family law matter. So that is not a national standard. It's not even, I don't think any states have gone that far yet, but certainly California is one of the states that is looking at that more closely and talking about it. There's a whole lot happening in the profession. But so the right to counsel is strictly just for criminal proceedings, but it wouldn't surprise me if in so many years we see that changing and perhaps being extended in other areas. If not from a national standpoint, maybe on certain states, but there's a lot to consider there. So at any rate, so what I've given you is some of like the leading cases here, and I may post up some content. Like I'm trying to add more things that you guys can watch, because I know some of you have a lot of time. Some of you maybe, I feel like I'm busier than ever, but with my own kids at home, but some of you may have more time. So I'm trying to find like some good videos, some good information that I can pepper in that you can watch if you'd like to. But so the big case is Powell versus Alabama, because previously, right, they would deny someone an attorney in a capital case, like a death penalty. So Powell versus Alabama was the case that really said, hey, you have to provide them an attorney in a death penalty case, but if they're not facing that, then okay. And so Gideon versus Wainwright is the very, very famous case that you might hear a lot of people, Gideon, have heard of that Gideon standard, where you have to be given an attorney really in any case that's a felony. And at this point, the era we're in is that it's any case where the person would be facing imprisonment. So, because you could actually have imprisonment even under a misdemeanor. Excuse me, hold on. Any rate, so there's a lot of good videos and information about Gideon in that case, and so I may try to add some in for you guys on that one. Let's see here. Yeah, there's a famous, very old movie about it, so there you go. But at any rate, questions on that one? Oops. Okay, so the next question you want to ask yourself is, okay, I know I have this right to counsel, but when does it accrue? When does it become ripe? Like I have a little lime tree in my backyard. The limes are growing. When is the lime ripe that I can pick it and put it in my Diet Coke? When is it ready? So I have a lime tree, but that doesn't mean that I have like actual limes I can put in a Diet Coke at all times. So you have this right, but it doesn't necessarily mean that at any moment you can go pick it. When is it ripe? When is it accrue? When does it come due? So there's been some the transformation over time of this standard. And generally speaking, before trial, like any, before trial, but obviously there's a lot of stuff that happens before trial. So at this point, from the Escobedo versus Illinois, is that once there's suspicion on the subject, and certainly once they're in custody. So in California, what you see is the minute someone has, right, their arraignment, that's when they ask them, will you be needing counsel? And then after the arraignment, right, that's when the counsel is assigned. So before the prelim, before the pretrial proceedings. So they get arrested and they appear for that arraignment. And then at that time, it's, will you be having your own counsel? Do you need public defender? And it's assigned then. And so, anything else after that point is when they're going to have an attorney. Is pretty typical. But there was some, could you just, you don't need an attorney until the day before your trial starts, No. So you'll be getting one, really, even if the suspicion has targeted into you, you may even be due an attorney. So. Oh, look, I'm right to counsel, there we go. Oh, I'm not gonna play this clip for you on the video here, but when you go back and look at the slides, this is just one of the greatest scenes of someone representing themselves ever. Of course, it's from Good Will Hunting, and it's just kind of a fun little movie clip. Aaron's like, play it. I don't know if it'll play. Hold on. Okay, I'm gonna try. I'm gonna try Aaron just for you. I don't know if you'll be able to hear it. Who knows, right? I don't know. Can you guys see it? Maybe you can see it. Okay, hold on. Oh, people are like, yes, we can see it. Hold on. Wow. So you may want to go back and add that to your quarantine watching. But at any rate, so this idea of representing yourself, one of the things the court is going to look at, and this is picking up on page 171, are you making a knowing and intelligent waiver of your right to an attorney? Okay, so you have that right. And if you let it go, so remember in the law, waive, W-A-I-V-E, kind of means the same thing as waive it, bye-bye, right? I'm moving too fast for my camera. Waive it, bye-bye, let it go, right? It's the Elsa. You're gonna let it go. So you have the right to an attorney. If you waive it, if you let it go, how does that play in, right? And so in order, just like anything, right, whether it's Miranda, right, waiving Miranda, waiving, maybe consenting to a search, right, all of those things, the courts will always want to know, was it knowing, was it intelligent, was it voluntary? Did you understand what you were doing? Were you coerced in any way? And obviously, we don't want any coercion, and we want to make sure the defendant knows what they're doing because it's a significant right. So is it a knowing, is it voluntary? So you'll often see in actual cases, if someone, especially for something serious, if they really want to represent themselves, and in California, we call that going pro per, okay? If you watch a lot of crime shows, that are more nationwide, you'll hear it referred to as pro se, like if you follow a lot of crime. But it means the same thing, but in California, we use the term pro per, meaning you're going to represent yourself. So especially if it's a more serious case, the judge will often probe, have a question answer session with the defendant on the record. Do you know what you're doing? Do you understand you're giving up the right to counsel? Do you understand that you're still going to be held to the same standards, as the attorneys? I think they try to give them as much wiggle room as they can, but the code is the code. If it says this motion has to be filed in 30 days, you've got to file it in 30 days. So those are the kind of things they'll want to think about. But you do have the right to represent yourself. And even when you have an attorney, defendants have the right to direct the counsel, to direct the attorney and how they're representing them, which is another reason that you want the defendant to be competent. Meaning, the attorney could say, well, you could plea this, or we could go ahead and go forward on that. And you want the defendant to be competent enough to be able to understand that and give an answer. And if they're incompetent, if they cannot do that, then that's why the proceeding would have to halt. So even if you have an attorney, it's still the defendant is still ultimately the one making the big decisions. But if they have waived their right to counsel, oh look, I should have gone back. I've got slides. Yeah, we want to look at the knowing intelligent waiver. But one of the things that comes up, especially in the more serious cases, is what's known as the standby counsel, or maybe advisory. So you may say, I want to represent myself. This is a 3 homicide case. I'm facing the death penalty. It's very serious. And if that's considered to be knowing and intelligent, okay, great, you're representing yourself. Then it becomes the court still wants to protect the process. We don't want to have 6 months, 5 years later, if the whole conviction, potentially the whole process, set aside by what is known as an ineffective assistance of counsel, right? So ineffective, I'm just going to type this in the chat, or IAC claim. So ineffective assistance of counsel. This is where you're going to say, hey, I would have never pled guilty, or I think I would have won my case, but for my attorney. My attorney made a mistake, right? Where you're kind of seeing this unfold in real time right now, if you follow politics or have time to go down a deep rabbit hole, is some of the stuff with Michael Flynn, right? He fired his previous attorneys. If you don't know who he is, that's fine, and has new attorneys. And so that seems to be that part of the argument they're establishing. But at any rate, but you will see this. Someone gets convicted of a very serious crime and they want to appeal it. And, you know, they have little grounds to appeal on, except perhaps the attorneys previously made mistakes. So they will launch an IAC, ineffective assistance of counsel. You know, you should have made this argument. You didn't bring this evidence forward. How come you didn't test for fibers, you know, or something, or how come you didn't question this person, you know? And now it's a very close look at every single move that their counsel, their attorney made. And, you know, there are times where that is a winning appeal, okay? So it takes on another dimension when the IAC claim, the ineffective assistance of counsel claim, is made when the person represented themselves. You know, like, what? But yet they are still allowed, they could still make that argument. You know, I didn't really know how the process worked. I didn't really know I could do this. I didn't understand. And so you can imagine that that could go on, because there is a lot of specialized work that goes into, whether it's just the creating of the different paperwork and filings, understanding the interplay of deadlines, how to question witnesses. All of those things are very technical. So the more serious the case, you know, if it's a basic misdemeanor, yeah, probably you could defend yourself just as good as an attorney. You know, I don't know, you know, maybe. I wouldn't recommend it. But as you get to more serious cases, the judge might say, look, I recognize that you are making this knowing and intelligent waiver, but I am going to bring in public defender or assign someone as your advisory counsel or standby counsel, meaning that they will advise you on the forms or kind of walk you through the different options. And you're representing yourself, they're not representing you, but they can make sure that, you know, you're not forgetting something completely, and really help prevent the IAC claim that you might try to file 6 years later, right? Trying to get out from underneath this conviction. Like, we'll make sure that you have everything you need, you know, you have all the documents, you understand the procedure, and that's very kind of interesting. And then the ultimate kind of like a next level of this is where someone has an attorney and they want to take the stand, and maybe they want to lie, and perhaps the attorney knows that they're going to lie. So the attorney, under their ethics, is not allowed to suborn perjury. They're not allowed to put forward something to the court that they know is a lie, right? I'm sure it happens when you don't actually know, but you can't put something forward that you know is a lie. So then you get into the situation of the defendant, who has the right to control their overall counsel, says, I want to take the stand and I'm going to lie. I'm going to lie and say I didn't do it. So sometimes, very extreme cases, you might have the attorney then you know, with the full court, with both sides, but they'll approach the judge and they'll say, I need to come off as counsel for 2 days and be assistance counsel, be advisory counsel, and then I can come back on. But I, you know, for reasons I can't even say, right, because of different ethics, but I need to be let out because I can't jeopardize my ethics. That's very extreme, but it's happened a few times. So I'm kind of cool on that. But, you know, and there's all kinds of reasons, and maybe you can think about, you know, why someone might want to represent themselves. But generally speaking, it's probably not recommended. And really the public defender's office, the alternate defender's service, the federal defender's office, some of the most, I don't know, some of the most experienced, best defense attorneys out there. And a lot of private defense attorneys started, you know, at those offices and then became private to take on more high profile cases. So at any rate, do you guys have questions or comments on any of that? People getting snacks. I support it. I'm gonna have a sandwich after this. Let's see here. Any questions on the right to counsel? I'm just kind of looking through a few things here. Oh yeah, and we kind of talked about that. Effective counsel. Yeah, we might come a little more into this. This kind of just takes you through the end of the chapter, everything we've just been talking about. Questions? Guys all asleep. Okay, so I guess I'll just move on. And then we get to the confrontation clause, or the right to confront the witnesses. So here you go. If you're the accused, if you're the defendant in a criminal trial, you know, have the right to be at your trial, which we already talked about. You could be either voluntarily absent. You know, you can imagine sometimes where you flee, you know, the trial starts and maybe you fled before the jury verdict came back. That would be voluntarily absent and the trial would probably still go on. If you flee before it starts, they might pause it while they find you. But at any rate, or if you're being disruptive. So, okay. Okay, Mark, great. The accused does have the right to face live testimony of witnesses. And they also have the right to challenge that, meaning they have the right to ask questions. So it's not a one-sided testimony. This is why you can also see the adversary system, the adversarial nature of the system, meaning it's not just the witness gets to get up there and tell their story. The other side gets to ask witnesses questions to challenge their story. So it's both, right? The defense has to have the opportunity, the defendant, to see that witness and to face them. And there, you know, there's a lot of psychology, you know, that's kind of behind this idea that the witness should have to face the defendant, literally face them and say, you did it, that's very powerful. And some of you who are into victims' rights and things like that, you know, I think it's powerful for the victim as well. It can be very challenging as well, but it can be very powerful for that victim to also face, you know, the person they've accused. But so the defendant has the right to have that person face them. And there's a couple cases in here where they even talk about putting a screen, you know, if the defendant couldn't see the witness because a screen was placed over them, that did not meet the confrontations clause requirements. Because again, the idea is you have to look me in the face. It's sort of this kind of psychological thought that people will be able to tell who's lying, who's telling the truth, you know, that kind of thing. And then second, right, they have the right to challenge. So you can't just have one-sided testimony. And this is why preliminary hearings, where you do have evidence that is presented, but there's no questioning because, right, it's just a probable cause determination. Preliminary hearing testimony cannot be brought into a trial because it was not challenged, right? The defense didn't have a chance. Oh, hold on, I gotta phone a friend. Hold on. Okay, so my friend just jumped in. Let's be clear. Preliminary hearing is the first chance a defendant has to challenge and confront the witnesses. And they are allowed, at least in California, to do cross-examination of the witnesses there. And so if it was cross-examined, then that testimony could come in. Grand jury testimony, which is not cross-examined and the defendant does not have the chance to confront, cannot come in. So little fine point there. So preliminary hearing testimony can come in if it was cross-examined, if they took that chance. Anyway, so we're lucky that I have a phone a friend. Let's see here. Then we get to the right to trial, and we'll probably come back in. So I'd say today is just a little bit of a preview here. Right, typical things you want to see: fair and impartial jury, a jury of your peers. The federal constitution only requires them for felonies, but obviously most jurisdictions have extended that, or maybe California is one of the few that have extended juries for misdemeanors.
Everything west of the Mississippi.
Okay. My phone a friend just told me everybody west of the Mississippi now allows for juries in misdemeanors at the defendant's option. And so there you go. So that would cover California. But on the East Coast, they only do it for felonies. But the federal constitution only requires it for felonies. You have two different main classifications of trial. So you have a bench trial, which means it's just a judge. So you could have that for a misdemeanor. And then you have a jury trial, right? And that's what we kind of imagine. So with a jury trial, you have a judge and you have the jury, and they each have a different role. So with a jury trial, the jury is literally weighing the facts. Like, do I believe the light was red? Do I believe the light was green? And they are making the factual determinations.
I really don't want to turn 24 tomorrow.
Michaela, bless your heart. I just muted you, but I'm excited for you to turn 24. So if you have a question though, unmute yourself, feel free. So the judge makes all the legal determinations, like something, is this evidence going to be allowed to come into trial? Is it appropriate? Did the defendant waive this right? And the jury makes the factual determinations. And right, and you probably know that, you just haven't thought about it that way. They don't make determinations throughout the trial, but at the end of the trial, they tell you who they agree with, right? Were they guilty? Were they not guilty? And so they're making their determinations at that point. We could all hear you, Michaela, saying you didn't want to turn 24 tomorrow. I don't know what happened to your microphone. It was just one thing, but we love you. We're here for you. Yeah, everyone's sending you digital birthday love. It's all good. It's no problem, Michaela. I'm probably going to have like a tiny dancer come up here in a second. So we're all just sending each other good vibes in this crazy situation. So I don't even know what's going on. Where am I? Okay, so the Sixth Amendment. The defendant can waive their right to a jury trial. Again, it's their right to waive it or not, okay? And the defendant can't necessarily force the bench trial in some situations. If it's not, like if it's in California where it's an option, you could have a bench trial or a jury trial for a misdemeanor. So it could be something where the prosecution also has to weigh in on that, because we really, for the most part, want to have juries of our peers. It's part of the system being open to the public and making those decisions. Oh my goodness. I know you guys, all of our birthdays are, everyone having a birthday right now. Oh, right. It's like kind of crazy. It's kind of crazy. So jury trial. If you're facing 6 months or less, I think this is actually about, I'm losing my train of thought. What time is it? Your attorney. 6 months or less, but in California, you would have an attorney for that. A fine of $500 or less, or something that's considered a petty offense, like an infraction. So we have a lot of things that have been classified as infractions now at this point. Wouldn't necessarily. Oh, this is a fun one. So this idea of 12 people, there is a lot of deep rabbit holes on does a jury have to be 12, right? From the Constitution, like most states have just codified it anyway, but you know, from the Constitution of the United States, do you have to have 12 people? Well, it doesn't say that. And so no one's quite sure where this idea of 12 first came from. But at this point, it's in the systems. But you will have some cases where certain jurisdictions will do it with less than 12. Again, certain states, I should ask my phone a friend, hold on. My phone a friend is, I think, making popcorn, but so for criminal, it has to be unanimous. And so whether it's 12 or, you know, 9 or 10 or something, for I can't think about it, for a guilty determination, it has to be unanimous. So if it's 11-1 or, you know, 10-1 or something, that wouldn't work. Civil cases, you can certainly do less than 12 and you don't have to be unanimous, but for criminal cases, it has to be unanimous. And so that's where it's sort of that comment is you only need one juror, right? Because I just need one juror to believe completely and utterly that I am not guilty and to refuse to budge. And that in and of itself would cause for a hung jury, right? If it's 11-1 and that one person believes I'm not guilty and all the other 11 believe I'm guilty, that would be enough to cause the hung jury, which would mean I could not be convicted. Now they might try again, but I couldn't be convicted. But yeah, so certain things you can't be less than, certainly not less than 6. And I don't think any, I gotta think, I feel like there is a state. Hold on, let me check my phone a friend.
In those states that do have jury trials for misdemeanor cases, you can go less than 12. And by statute, you could also go non-unanimous verdicts.
Okay, yeah. So I'm just hearing from my phone a friend. Some states allow less than 12, but most often only for misdemeanors. And in those states, they also most likely have a statute that would, for misdemeanors only, allow a non-unanimous jury. But I don't think California is one of those. Even for misdemeanors, it has to be unanimous. And we're 12 for misdemeanors in California. So if you're ever sort of like wondering, like, what's the standard? Ask yourself, what's the most protective to the defendant? And that probably will give you the best idea about where California is. And I'm getting like a weird message, so I hope this is working. I don't know. It doesn't like this right now. Can you guys see the screen? I have no idea. I think the jury trial is not good for the defendant. Khaled saying, it really depends. I mean, some people really view it, you know, there's something powerful about having 12 people like look at the defendant and look at the evidence and decide. You know, yeah, it's getting an odd message. I don't know why it hates me right now. It's giving me a thing, but I think it just depends. You know, there are certain cases where, you know, a lot of like sex abuse or child sex cases where the defendant will say, I do not want a jury trial. I waive my right to a jury trial. I want a bench trial, serious felony. And some of that is thought because, you know, it's very emotional, that the idea is maybe the jury won't be able to, you know, really set aside their emotion of that crime to hear the evidence. But again, it's up to the defendant. And I don't know why it's giving me this weird message. But yeah, that's up to them. But otherwise, you know, I don't know. People like it. It's just it's probably a deeply debated point is whether or not a jury is good for a defendant or not. But I mean, they often will find people not guilty. So it happens. I've got these notes about public trial. I don't know if the internet is just, you know, disliking all of this right now. But Trials are open to the public. People sometimes are surprised about this. You could go, not right now, given the coronavirus thing, but instead of doing trials in secret, they've just postponed jury trials right now. So that way, when they resume, it's when the courts will be back open, you know, and I'm not sure what the distancing issues will be, but they are open. The proceedings are not secret. The members of the public can attend. You can limit the number of people who attend, right? You can even do things with like video conferencing, things like that, you know, or only so many media, you know, where you have to show up every day to get a spot kind of thing. If people are being disruptive, then you can obviously have them leave. So if you ever do go to observe court, you know, just assume that the bailiff will ask you, the sheriff, you know, why you're there. Are you just a member of the public? Are you, you know, the victim's family? Are you related to someone that's on trial? You know, just for a sense of security. But they can't close the entire trial. Every once in a while, especially involving juvenile cases, they might have something where juvenile proceedings are treated differently. But if you have a juvenile who is a witness, you could have that small, very small portion after a lot of back and forth trial would be closed to the public, but obviously everyone's still there. But the rest of the case would be opened back up. But even that is considered a bit extraordinary. And pretrial hearings are not considered public. You can often go to them, but that's not the same level of right that jury trials have. Yes, there's a lot of debate, Khaled, and you could, you know, add that in as kind of your own personal study about, you know, just lay people making decisions. Is that good? Is it bad? And you're going to find like mountains of arguments on both sides, you know, of people arguing jurors, you know, make terrible decisions, people arguing jurors are the best people to make these decisions. And then you start, well, what's the other alternative? Do you have, I don't know, who makes the decisions? So it's very interesting, but there's a lot of interesting research. And when you look at how they pick a jury, right now it's based on geography, right? The geographic location of the trial and who lives within that certain geographic location. Those are the people that are called up to be jurors. And, you know, is that a jury of your peers, you know, where you live or where the crime was committed? So that's another very interesting dynamic. And I don't think we get into that too much in this class, but who knows, maybe we'll pepper some things in later, but very interesting. And then I've just put in a few links, and these are more for you guys just to kind of watch on your own, because, you know, I know we're kind of doing whatever. So I've got like 3 or 4 different links here that are from, you know, good sources that I've looked at. So this is the Quimby. They like do these little kind of cartoon videos of really important cases, and it's from University of Utah Law School. Very legit resource that they've been putting together, and then a few others. So I encourage you guys to kind of check those out, because, you know, I know some of you have books, some of you love books, hate books, whatever. You might have more time, and they're all short. These are all fairly short videos, but we won't play them right here. But you guys can watch those. And then let me look here. Oh, and I haven't been watching that Just Mercy. I think, is it a TV show, Diana? I haven't seen it yet. I'm gonna stop the recording right here, and then I will get back to your questions.